Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding the allowability of the various expenses which are done by the assessee on the cost of improvement of the property which the assessee sells and claims from the sale consideration. In the assessment proceedings, it is generally seen that the revenue authorities are very reluctant to allow the various expenses which were very necessary to make the property habitable as claiming the expenses as cost of improvement. For example, the expenses done on air conditioning, modular kitchen, expenses on the lift, submersible pump, etc. This issue has been taken by the Honorable Delhi ITAT D bench in the case of Rajiv Ghai versus Assistant Commissioner of Income Tax, International Taxation. And this case has been reported in 109 ITR Tribunal at page number 439. First of all, in this case, there was an issue that the assessee has claimed exemption under section 54F. As per the strict interpretation of section 54F, the property should be purchased into the name of the assessee. Since in the present case the assessee was not in India at that time, so the assessee purchased the property in the name of his father. And when the assessee came back from the foreign country, the parents gifted this property to the assessee. All the funds which were necessary to purchase the property has been transferred from the assessee's account. So on this limited issue also, the assessing officer was of the opinion that the assessee should not get the exemption under section 54F because the property has been purchased into the name of the father of the assessee. When the whole facts and circumstances were examined by the tribunal was of the opinion that in the present case, the investments had been made from the account of the assessee. The assessee was not in India, and after his visit back to the India, the property was transferred by the parents in the name of the assessee by way of gift. So on this ground, section 54 exemption, section 54F exemption cannot be denied. The second issue was that the assessee has claimed some expenses like air conditioning, modular kitchen, lift, and submersible pump as cost of improvement from the sale consideration. And the assessee has submitted the valuer report regarding these expenses, but the assessing officer was of the opinion that since in the sale deed the mention of these expenses are not there, that these were the items which were installed in the property, so the assessee should not be given the benefit of cost of improvement. It is a practical difficulty that whenever the properties are sold and some expenses are done for the cost of improvement, generally the properties are sold after a long period of time, so the assessee may not be in the possession of all the bills. So the best way is that when the assessee is selling the property and when the assessee is making the computation of income and filing the return of income, it is very advisable for the assessee to obtain the registered valuer report. But this report should be obtained at the time of filing the return of income. The assessee has submitted the valuation report at the time of the assessment proceedings, but the assessing officer, without pinpointing any inconsistency in the valuation report or without declaring the valuation report as wrong, go ahead with disallowing the various expenses on cost of improvement. The assessing officer was also of the view that the lift is not required or the expenses on air conditioning, submersible pump and modular kitchen are not necessary to make the property habitable. So these expenses should not be allowed as cost of improvement. When this matter was heard by the tribunal said that the assessing officer version that the lift was not required in the property, it is not the purview of the assessing officer that whether the lift is required or not. And moreover, in the present case, the age of the father of the assessee was 90 years. So it was very much necessary to install a lift because a person who is of 90 years of age cannot use the property without lift. And as far as the other expenses like submersible pump, air conditioning and modular kitchen, the ITAT was of the very clear opinion that these expenses are very much necessary to make the place habitable, and they cannot be disallowed just on the basis of presumptions and surmises, and they should be allowed as cost of improvement. At the end of this video, once again I am repeating the name of the case. The name of the case is Rajiv Ghai versus Assistant Commissioner of Income Tax, International Taxation, and this case has been reported in 109 ITR Tribunal at page number 439. The date of the judgment is 26th December 2023. Thank you, friends.